Hello. Are you studying for your state property casualty test, either general lines or personal lines? Are you learning about the basics of liability? Well, we're going to cover these important topics in today's video, and be sure to stick around to the end where we'll take a look at a practice question to help you get ready to pass that state test. Let's get started. Welcome back. Now, we're going to cover this important topic of liability basics. There's a couple of things that are in here, actually a bunch of things that are in here that we're going to go through. Let's start with the concept of contract law versus tort law. In our legal system today, if you break the law, you'd end up in the what? Criminal courts. If there's a lawsuit for something that's not breaking a law, then that ends up in what's called civil court. Now, in civil court, there's two things. There's contract law, which is the breach of a contract, and that's not what insurance is about. And then there's tort law, which is the breach of a duty. And basically what liability insurance is, it's protection against those lawsuits that have to do with that tort law. So what is that in the real world? Well, liability insurance is lawsuit protection. It protects you against those lawsuits that have to do with tort law. This is also called casualty insurance. If somebody sues you for some damage, then you have to be ready to settle that claim or take care of that claim. And those claims can be very, very large. That's what you need the liability insurance for. Now, an important term here is plaintiff or claimant. That is the person that is filing the lawsuit. The defendant is the person that is defending themselves. It would be the defendant that would have the insurance policy, the homeowner's policy or the auto policy that would have that liability coverage. Now, a key point here is that liability insurance has to do with civil wrongs, and a tort is a civil wrong other than a breach of contract for which the law provides monetary damages. A lot of policies really only cover bodily injury and property damage, and there's a lot more that can be involved in that other than bodily injury and property damage. So in other words, a tort can be a violation of a right. The rights that individuals have include the freedom from bodily injury and property damage, the freedom from interference with family relationships, the freedom from psychological trauma, the freedom from interference with economic rights, and the freedom from damage to public image. And you can be sued for any of those breaches of that right that somebody has. Those lawsuits, once again, can be very large, and that's what liability insurance is for, is to protect you against lawsuits. Now, you can get coverage for just about all of those, but the property casualty policies we typically talk about are covering bodily injury and property damage. Now, in order for a plaintiff to prove legal negligence, they have to prove 4 elements, which is that you failed to use the degree of care considered reasonable, with 4 elements: duty to care, breach of duty, causation, and damages. The plaintiff must prove all 4 conditions existed in order to be able to hold the defendant legally liable for negligence. So let's go through these 4 items very quickly. First off, there's the duty to care. You have a duty to do something or to keep from doing something. That would be things like all drivers stopping at red lights. Other duties recognized by the courts, such as the duty to take reasonable measures to protect other people from foreseeable harm, such as shoveling snow from a walkway. The next component is breach of duty to care. Was there a breach of that duty? Well, leaving snow or ice on somebody's sidewalk is obviously a breach of that duty. So is simply owning and operating an auto that accidentally hits somebody else. You have, by definition, breached your duty to care, or breached your duty not to hit somebody with your dadgum car. The third component is causation. Was this breach of duty the proximate cause of the loss? Was it based on the defendant's actions, inactions, or their legal responsibility? And then finally, were there damages? There have to be compensatable damages in order for there to be legal liability. Let's take a quick look at a question. The question says, while driving his red Mercury, Joe Smith ran a stop sign, causing another driver to swerve to avoid a collision. Was Joe Smith legally negligent in this situation? I think that you or I would call Joe negligent because he was doing some crazy stuff. But there was no damage. So the answer is D, no, there were no actual damages. So Joe Smith is not legally negligent in this situation. Now, if somebody is legally negligent, the court can award two types of damages: special damages or general damages. Now, special damages are tangible losses. These are things that would have a receipt: doctor's bills, prescriptions, loss of income. General damages are things that are subjective, not objective. So these are things that would not have a receipt. These are things like pain and suffering that are very difficult to measure in dollars. Now, one way to remember this, we remember in pictures, we don't remember so much in words. Try to picture a general. You can make him a cartoony general. So this is a cartoony general with a big cartoony general hat on, and he's sitting behind his great big cartoony general desk, and he's looking through his desk drawers, and he's looking through his cabinets, and he's looking all over his desk because he can't find his receipt. There's this important receipt he needs, and he can't find a receipt. And the general doesn't have a receipt. That helps us remember that what? General damages do not have a receipt. That's for pain and suffering. Special damages does have a receipt, and that's things like doctor's bills, prescriptions, and loss of income. Now, the courts can also award punitive damages, but remember that punitive damages are never paid by the insurance policies. Then we have our defenses to negligence. We're going to talk about assumption of risk and the difference between contributory and comparative. Now, assumption of risk is really simple, and on the test, it always appears like this. It always appears as sports stadium. If the plaintiff knows or should have known that they're putting themselves in danger, then the defense here is called assumption of risk. But like I said, it's always sports stadium. So in your notes, I would write assumption of risk equals sports stadium. Let's take a look at a question. Gavin is seated behind the goal to watch a hockey game when a member of the visiting team hit a puck that sailed over the top of the goal and struck him, breaking his jaw. Gavin sued the team, but the team's lawyer held that Gavin willingly exposed himself to the possibility of injury, a defense that is based on the sports stadium. That's easy. That is assumption of risk. And then finally, we have contributory versus comparative negligence. Now, some states are contributory states. Some states are comparative states. Most states are comparative. There's only a few left that are contributory. But the question on your test is not going to be, what is your state? Although you should know what is your state. But the question is going to be, what is the difference? Now, this has to do with a situation where both people are a little bit at fault. The classic example is two cars backing out of a parking lot at a grocery store, for example, and they bump into each other. Now, they were both moving. They were both a little at fault. So how do we handle this? Well, in a contributory state, if the defendant was even 1% at fault, then they get nothing. In a comparative state, they're going to compare. So the judge is going to look at the two situations and they're going to compare. You're a little bit at fault, you're a little bit at fault, and the judge or the jury is going to assign a percentage of negligence. The person that is a little bit negligent will not be able to collect based on their percentage of negligence. In other words, if somebody was 20% at fault, they would have 20% less that they could collect. They would only collect 80% of their damages. In other words, less 20%. In that situation, one person is going to what? Collect 80% and the other person is going to collect 20% of their damages based on their portion of fault. So once again, how to remember that? In a contributory state, if you're a little bit at fault, you get nothing. In a comparative state, we're going to compare, and the amount of your claim is reduced by your percentage of negligence. Now, let's take a look at one last question to help you get ready to pass that test. The question says, Sally was seriously injured when she collided with Frank at an intersection. The court determined that the accident was 20% Sally's fault, so she was entitled to recover 80% of her damages from Frank. The defense was based on what? Sally's going to get something, not nothing, so it's not contributory, it's comparative. Okay, so that wraps up that concept, and I hope that helped you folks, and if it did, please give us a like. If you haven't yet, please subscribe, and be sure to check out mortonschools.com, where we have all sorts of pre-licensing and continuing education classes for all sorts of different types of insurances and securities. Take a look, and once again, thank you folks very much for joining us. We'll see you on the next one.